proposed rules and regulations to the commission. And we will open up the hearing on Senate Bill 211 with an overview of the legislation from our revisor of statutes. Tamara Lawrence, welcome to the committee. Revisor Lawrence.
Thank you, Mr. Chairman, and good morning, committee. Current law requires the Secretary of Wildlife and Parks to submit proposed rules and regulations to the Wildlife and Parks Commission, and the Commission either approves, modifies and approves, or rejects those proposed rules and regulations. Senate Bill 211 would amend KSA 32805 to include members of the Commission in that requirement. So if a member of the Commission has a proposed rule and regulation, that member would have to submit it to the Commission for review. There is one technical amendment, and the bill would take effect on July 1 upon publication in the statute book, and I'll be happy to answer questions.
Committee, do you have questions of our revisor? Senator Reichman.
Thank you, Mr. Chairman, and thank you for your presentation. My question is, how long have we had it, this rule?
I will have to check the legislative history on that, but I will do that when I sit back down.
All right, thank you.
Additional questions, committee? Seeing none, thank you for your information. Our first conferee, it appears as though it is via WebEx, Bruce Riel. I don't know how you pronounce the name, but we will learn. He's a commissioner with Wildlife and Parks. Mr. Commissioner, are you online? We're working on a connection here, Mr. Commissioner. He is on or he is not? He is on, okay. Mr. Commissioner, can you hear us? If you can, no, that's Secretary Kobach. We don't need to, or I'm sorry, AG Kobach. Looking good today, but that's not who we need to see right now.
Thank you, Mr. Chairman. Yes, this particular statute was enacted in 1987, and the requirement that the Secretary submit proposed rules to the Commission was part of that original enactment in 1987.
Does that fully answer your question, Senator? All right. All right, Commissioner Riel, however you pronounce your name, you are up. If you are on our end, it looks like we're ready to go.
Yes, can you hear me?
Yes, go ahead. You're on.
My name is Bruce Riel. I serve as Commissioner for Kansas Department of Wildlife and Parks, representing Region 4, which is the Southwest Kansas region.
We might ask you to turn off.
I believe I would have a meaningful.
Mr. Commissioner, we might ask you to turn off your video because you are breaking up really bad on the audio, and sometimes eliminating the video will allow the audio to come in.
Okay, let me try that. I'm sorry, I'm traveling right now. It's not great. Okay, is this any better?
Well, we'll give it a shot and see. By the way, how do you pronounce your last name, sir?
Riel.
All right, go ahead, Mr. Commissioner.
So I'll start though. My name is Bruce Riel, and I serve as Commissioner for the Kansas Department of Wildlife and Parks, representing Region 4, which is the Southwest region of Kansas. When I accepted this role, I believed I would have a meaningful. Unfortunately, that's not been the case. Right now, commissioners are being sidelined. The Secretary alone decides what regulations can be proposed. Leader is little more than a rubber stamp. or proposal to extend the use of full equipment piloting.
Commissioner,
strong public
Commissioner,
support.
I'm going to interrupt you. Commissioner, I'm going to interrupt. This is not working. We're only getting about half of what you're saying. I don't know if it looks as though you are certainly in a vehicle. I don't know if you were to move your location, if you would have better reception, because we do want to hear what you have to say. If not, we can go by your written testimony.
You might have to go by my written. We're in a bad signal area right now in western Kansas, so I don't know that it's going to get any better for a bit.
Well, right now, you're coming through acceptable. We'll go ahead and give you another opportunity. We'll give it a shot.
Okay. So with the strong public support for this proposal, the secretary moved forward on it, and we've gone through 3 meetings, and nothing has been introduced for regulation for consideration. Bringing the bill SB 211 ensures commissioners can propose agenda items. It does not bypass the democratic process. Everything would still require a majority vote, but it would prevent a single individual from blocking necessary discussions. Moreover, we need transparency in our decision making. While I deeply respect our biologists, I've observed how research findings sometimes seem to be with a predetermined outcome. States look at the same issues and reach entirely different conclusions. We need unbiased information to make the best of Kansas wildlife. Restricting regulatory discussions to one agency official contradicts the collaborative spirit of conservation. SB 211 would restore balance, ensuring that all voices, especially those of the people we represent, are heard. I urge you to support this bill, and thank you for your time.
All right. Appreciate your testimony. And again, we have your written testimony, Commissioner Riel, in front of us. We will go ahead, committee, and attempt to see if we can do a Q&A with Commissioner Riel. Committee have questions of Commissioner Riel. Seeing none, Commissioner, we appreciate your best attempt at an oral testimony, and we do have the written. So we will move on, committee. Commissioner was the only proponent that we had listed. I do have a written proponent from Attorney General Kobach, from Commissioner Keith Mark, and a Mr. Kenny Graham, SR trustee, Kansas Outfitters and Landowners Association. So you have their written testimony as a proponent in your folder, committee. So I would urge you to glance through that as you have an opportunity, potentially in this meeting, if not, certainly afterwards.
Mr. Chairman? Mr. Chairman?
Yes, sir. General Kobach, were you wanting to testify orally?
Yeah, I was wanting to testify orally. I don't know how the message got in that was just written only, but if I may.
Absolutely. Go ahead, Mr. General.
Well, thank you for the opportunity to testify. I apologize that I'm not there in person as I normally would be. This bill is just a small fix to what is actually a pretty big problem. As we all know, last year there was a bipartisan bill that was passed with support from both parties. The governor signed it to make the commission, the Wildlife and Parks Commission, more representative and better reflect the viewpoints of Kansans around the state. The commissioners would no longer all be appointed by the governor. Some would be appointed by House leadership. Some would be appointed by Senate leadership. The Attorney General, as Chief Law Enforcement Officer, would also have an appointee since the Wildlife and Parks game wardens are law enforcement officials. There's geographic representation on the commission. That's why we have districts representing the various parts of the state. I believe Commissioner Riel represents the southwest part of the state. And the idea was that the commission would better reflect the views of hunters, fishermen, campers, hikers, and people of Kansas who want to enjoy our wonderful outdoors and bring greater diversity of perspectives. Because I had an appointee on the commission as of last summer, I watched some meetings before, but I started watching every meeting just to observe the process and learn that there's a defect in Kansas law. I have no idea how it got there, but it only allows one person to propose regulatory changes, and that is the secretary. And that has led to a situation where the commission is nothing more than a rubber stamp. Only the secretary can put anything in front of the commission, and the commission just has to rubber stamp it or reject it or attempt to amend it. And currently, I've observed that the appointed secretary appears, as Commissioner Riel, I think, was trying to describe, either delay or shut down some changes. There's one very minor change regarding coyote hunting that has been discussed at 3 different meetings. Commissioners have asked for the secretary to put the regulatory change up for a vote, and he has so far declined to do so. And I think the result of this is it defeats representation. Imagine someone from Northwest Kansas speaks to their commissioner. He brings a problem or an issue or a proposal to the commission, says, I'd like to present this, but it never comes to a vote because for whatever reason, the secretary decides that this does not merit consideration. That's the situation we have right now, where the secretary can effectively squash discussion of anything. And imagine it this way, you're all legislators. You get elected to the legislature, and then for your first committee meeting, you learn that you actually do not have the ability to propose any bills. You do not have the ability to make any proposals in your committee meetings like this one. And that in fact, all proposals come from a bureaucrat appointed by the governor. You would have a rude awakening. You think, wait a minute, this isn't how our system works. We are a constitutional republic, and representatives in a republic, who are either appointed or are directly elected, get to represent their constituencies. Well, that's not happening right now, and I don't think anyone would say that would be an appropriate way to make decisions. Indeed, no governing body works that way. Whether you're talking about a county commission or a city council, all members have the opportunity to make a proposal, and it may get voted up, it may get voted down. You still have majority rule on the committee. Of course, the secretary or the staff, in the example of a county commission, would be able to offer their thoughts, either pro or con or neutral. But at the end of the day, the governing body gets to take a vote. You have 2 problems with the situation right now. One is that issues don't come to a vote. As I said, there was this relatively uncontroversial thing that regarding coyote hunting that Commissioner Riel, I think, was talking about. It's been discussed since August, but it hasn't even been put before the commission. They want to vote on it. Secondly, it defeats representation. Effectively, the only vote that matters is the secretary's, and he's not even technically on the commission. So I understand there may be 1 or 2 opponents to this. I can't think of a single counter argument to why you wouldn't let members of a committee propose things and let the committee vote on them. The only argument I can possibly think of is the notion that somehow the secretary has special expertise and special knowledge that makes him wiser and better at deciding these things. These things are matters of public policy, just like your committee has experts come before you all the time who have expertise in an area. That doesn't mean that the expert gets to decide it. It means you get to decide it after listening and weighing the evidence and testimony of the expert. So no matter what the expertise is of the secretary, that does not entitle him, in my view, according to the constitutional and representative principles of our system, to simply push aside the desire of the body to vote on it. And the other factor is then you effectively don't have votes on issues. Let's bring things to a vote and decide whether to go up or down and move forward. So just to summarize, this is a small fix, but I think it should be bipartisan in nature. I can't think of any reason why people would say that the members of a commission should have no ability to propose ideas to that commission. Thank you. I'd be happy to take any questions.
Thank you, General Kobach. Questions of General? Senator Francisco.
Thank you, Mr. Chair, and thank you, General Kobach, for testifying. So when we talk about how things happen legislatively, my understanding is this change would mean that it would just be a majority of the commission who would make that decision. Would you think it might make sense, just like the governor has a veto, for the secretary to have a veto unless there's a 2/3 majority of the commission?
So the bill doesn't change the required majority. That's already the case. I don't think so. I mean, this is an agency. This is not a legislative agency. It's a, I guess you call it a quasi-executive agency. You know, much like county commissions, they have both legislative and executive powers. You don't normally see county commissions where the county executive has a veto. And again, where a governor has a veto, the governor is elected. So the presumption is that veto reflects the will, the governor's perspective, representing all of the people of Kansas. So I don't think the analogy holds, with all due respect, Senator Francisco.
Thank you. I think there's a little bit of a difference. We really don't have any members appointed who represent science or, you know, the example that you're using is talking about hunting coyotes. And so if you're trying to maintain a population, I'm hoping coyotes kill deer, that should there be some input from that scientific or biological viewpoint. And I certainly know that, having served on a city commission, that there's times when a vote does require a majority. But thank you for your comments.
We do have a question from Senator Blue via WebEx. Senator Blue?
Thank you, Mr. Chair. I am driving in, and I apologize if you hear Sesame Street in the background with my daughter. But my question is for the Attorney General. I have had a ton of phone calls regarding the proposed coyote regulation change. I just am curious, could you go into more detail on it? You know, I'm wondering if I'm just hearing one side of it. But, and maybe it is in your testimony, and like I said, I am driving in your written testimony, but could you go into more detail over if it's what I think it is year-round night hunting for coyotes?
General Kobach?
Yeah, thank you, Senator. And I don't want to, this really isn't about one vote. That was just an example of how the process is working. And I think there are, you know, there are reasonable views on both sides of that. And the fact that you're getting phone calls makes the point. The 7 commissioners are getting phone calls too. And the perspective of people in Southwest Kansas may be very different, say, from the perspective of people in the greater Kansas City metro area. And so the whole point is you have representation, and the commissioners vote in harmony with the phone calls they're getting to represent the points of view they're getting. Right now, you effectively have, you know, just one person, the secretary, who doesn't represent any particular area of the state, just saying, well, yes, I will bring it to vote, or in this case, no, I won't bring it to vote. If it were brought to a vote, then it would be fine, and we would see how those views are reflected. And so it's, you know, I mean, the coyote, yes, that right now Kansas allows a night vision assisted coyote hunting 3 months of the year. But it does not allow it, like most states do, states that have it do for all of the year. I think the proposal would raise it to all of the year minus the rifle hunting days. But again, that's not the point. I think that's just an example of the process. This should have been voted on months ago, and move on to the next issue. But right now, things aren't coming to a vote because individual members of the commission don't have the opportunity to simply make a proposal.
Additional questions, Senator Blue? Apparently not.
Thank you. Nope, thank you.
All right, certainly. Senator Alley?
Thank you, Mr. Chair. That's maybe wordsmithing a little bit, but in line 2 of the bill, this is line 1, an act concerning wildlife and parks relating to the rules and regulations. Line 2 says requiring members of wildlife and parks to submit proposed rules and regulations. That is the way that it is in the reviser's statement. But when we go to the division of budget, they said Senate Bill 211 would also allow. I think to me, there's a difference between allowing the members and requiring the members.
Yes, Senator, that's exactly right. I did not notice that that's the label apparently the revisor's office put on it. No, it does not require anything. It just allows them. if they wish to make a proposal, and have the commission consider it.
If we look at the document that Acting Secretary submitted on the last page, if Senate Bill 211 were to become law, individual commissioners would have to complete this complicated process on their own, as the staff, legal staff, would be ethically precluded from doing it for them. I think they're interpreting something there that isn't there or wasn't the intent.
I think you're right, sir. The staff, there is an attorney who actually used to work in the Attorney General's office. He's a great attorney who works for the commission, and he would effectively serve like the revisor's office does for you legislators. He could simply propose language if a commissioner asks for it. I don't think this is something that is going to overwork an attorney. It's not as if they have 10 proposals at every meeting. So no, it doesn't. There's nothing unethical about having a general counsel serve the basic legal purposes of the commission and the secretary at the same time.
Thank you, sir.
Senator Shane.
Thank you, Mr. Chair, and thank you, General Kobach, for attending online today. Does a lack of graduate level training and scientific training preclude a commissioners from having the ability to provide scientific evidence-based proposals? And in your opinion, how many different scientific fields have a role surrounding the policies around conservation, hunting, fishing, so on and so forth?
Well, there's a plethora of fields. You're not just talking about wildlife biologists. You're talking about forestry. You're talking about agriculture. You're talking about all kinds of things. You're talking about managing many of our parks cabins, which are sort of a de facto kind of hotel arrangement. There are all kinds of disciplines that are involved, and the fact that well, first of all, I would say our commissioners do have a great deal of expertise. We have a professor on the commission from Pittsburgh State, I believe. We have at least one lawyer on the commission. We have several hunters on the commission. We have a lifelong farmer, rancher, I believe, on the commission. So you have a great deal of experience. But the point is the secretary's staff, every meeting, and I think this goes to Senator Francisco's question as well, the meetings I have observed, every meeting, staff will come in and provide all kinds of expertise and offer their opinion on a particular question. I also observed at the last meeting that one of the commissioners brought in several written studies of the issue and had an outside expert from outside of Kansas on the very topic testify via WebEx. So I think where you're going, Senator, is that yes, there are lots of disciplines. It's not as if you have a secretary who is this wizard of all things wildlife and parks. The secretary is certainly not going to be able to encompass all of the things that go into a decision, but you need the representatives to make that decision. Just like in the Kansas legislature, the representatives make the decision, weighing the input from their constituents and weighing any expertise that's been presented.
Thank you.
General Kobach, it had been mentioned to me that if this legislation were to pass, it would require the commission to take a vote on any suggested proposal or any proposal suggested by a commissioner at that meeting. I don't see that in the language, and I don't necessarily know that any suggested proposal change to rules and regulations would ever require a vote. But I'm not an attorney. Can you enlighten me just a little bit on that?
You are correct, Mr. Chairman. It doesn't require anything to come to a vote. It simply allows members of the commission, just like members of your committee, to propose things. You still have Roger's Rules of Order, and things can come to a vote if a commissioner moves for the consideration of a bill, or in this case, it would be a regulatory change. So no, nothing is required to come to a vote. Majority rule of the commission still prevails like it does now. It just allows more than one person to propose changes or policies or regulations.
So if there is a proposal currently from the secretary, pardon me, am I hearing that there's no requirement for the commission to take up that proposal?
That's an interesting question. I think the commission could table a proposal. I believe they don't have to take a vote. I have not observed that in the meetings that I've been watching for the past approximately 9 months, but I believe tabling a proposal is an option.
Thank you. That's the way I would read it, because there's a line that says the commission shall either approve and modify, or approve, modify and approve, or reject. So I would say a rejection would be a table or something. Okay, well, that answers a question that I had proposed to me, or a comment that I didn't necessarily agree it was accurate. But anyway, in any event, committee additional questions. Senator Francisco.
My apologies, Mr. Chair. This may be for the revisor rather than for the general.
Go ahead and ask your question, and we will see. They're both attorneys.
So my question would just be, since we're talking about rules and regulations, those would also have to go through the process, be subject to a public hearing. So would there be any changes we would want to make in this language? Because, in fact, if you says the secretary shall adopt such rules and regulations, it's really that the secretary shall work to have such rules and regulations presented, and they're not really adopted until after there's also public testimony. Is that correct?
Supervisor Lawrence, do you wish to answer that, or pass it on to the general? All right, we'll let you.
Thank you, Mr. Chairman. Yes, rules and regulations would still be subject to the Rules and Regulations Filing Act.
Fairly straight, simple answer.
Thank you, I appreciate that. And so if we do work this bill, we might want to also insert that language about subject to the filing act.
I might suggest you work on an amendment. Seeing no additional questions, General, we appreciate your testimony this morning.
Thank you.
Mr. Chair. Senator Ware here. I had my hand up, but our technology is smarter than me today, I guess.
Senator Ware, go ahead.
Thank you so much. And Attorney General, a lot of what you were saying is based on the equation between the legislature and this commission, but the commission is elected or appointed?
The commission is appointed by individuals who are elected. So you have sort of, quasi-representation. The governor is elected, and every other official who appoints someone is also elected. And then they also have this representation function where, unlike many commissions, they are, they represent geographic sections of the state. So there's clearly a representation going on. But you're right, it's not exactly like a direct election of a legislator.
Thank you.
All right, thank you, General, for hanging on just a moment. There's no more hands up, is that correct, staff? Okay, so we're ready to move forward. I did mention, committee, that we had a couple pieces of written testimony from Commissioner Mark Keith and Mr. Kenny Graham, a trustee with the Kansas Outfitters and Landowners Association. I do things in a little bit different order here. I will go next to neutral. However, we have written testimony, and I thought that it was going to be oral testimony from the secretary. You're going to speak on behalf of the secretary?
Yes, Mr. Chairman. I'm sorry, the secretary couldn't be here today, so he asked me to come testify, if that's okay with you.
That will be allowed since it's a department issue. You might identify yourself for the committee.
Yes, Mr. Chairman.
Testifying on behalf of Acting Secretary Kennedy.
Mr. Chairman, members of the committee, my name is Curtis Wired. I am the Chief Counsel of Wildlife and Parks. I'm also the aforementioned attorney that Attorney General Kobach mentioned. For those of you who don't recognize me, I've been with the agency for about 5 months now. Before that, I did work in Attorney General Kobach's office. So I've made the transition over here. And we are offering neutral testimony to this bill. In the acting secretary's written testimony here, we've identified a couple potential problems with the bill, though, for your consideration. and I think many of them already been discussed here. Before I get going, and I forget, Senator Reichman had a question about when this power came into being. I looked and found that it was at least in 1987, but because the library and everything else was closed yesterday because of the snow, I don't know if that power extends back to earlier, maybe the 1920s, but I wasn't able to check some of the older statute books, so it may have existed long prior to that. The gist is basically twofold here. The first is that what I've come to learn in my time at the Wildlife and Parks is that our constituency is very invested in issues that we discuss, and they have come to expect at our Wildlife Commission meetings several consecutive discussions of topics that are hot button topics, like, again, the aforementioned night vision hunting. So what we use the commission for, and I think what the statute is designed currently is the commission is used to facilitate public discussion, public notice, public debate of hot topics at consecutive commission meetings, and then then issues are brought to the commission for a vote. And that's currently what's happening. Just I'll divert, since it seems appropriate here, into the night vision hunting. For example, what's happened is Acting Secretary Kennedy has put this issue at the request of one commissioner in particular who was very interested in the issue. We've taken it very seriously, put it before the commission. Our last commission meeting was a couple weeks ago in Manhattan. I would encourage all of you to watch it. It's on YouTube. It was a very spirited discussion about night vision hunting. I prepared a 50-state survey for the commissioners to compare what all states do. We had a head of our law enforcement speak about issues of night vision hunting that we have, and then also our biologists speak about it. I'm currently in the process of gathering data on the public's views on night vision hunting. We're currently surveying the different hunters based on the data we have in the agency, a variety of hunters, to get their feedback on what they think of the matter, and we are taking public comments. So we are doing our due diligence, and I want to make it clear that we do take even a request from a single commissioner very seriously, and we put it before the commission. I think the acting secretary's intent is to put it before the commission for a vote, either in the March or April, hopefully the March commission meeting, depending on what data we can collect for the commission. So that's the first one, is that the public's view of how the commission works. The second point I make there, and which the Attorney General referenced, is the long process of promulgating a regulation. As I read the statute and how it's been historically interpreted, and I've checked this with the other attorney we have in our office, is that proposal, once the regulation is proposed to the commission, they then vote to either accept, reject, or modify. Before we get to that official vote, it's my job to run the regulation through D of A, Attorney General's office, Division of Budget, and then notice it up in the Kansas Registrar, and then also go before JCAR. So inevitably the question is, if a single commissioner has the authority to propose a regulation, who does that? And I want to emphasize that the reason I raise this is not a workload issue for me. He's right, it wouldn't add substantially to my workload. It's an ethical consideration as an attorney. I have to worry about my license and making sure that the client that I have, which is the Department of Wildlife and Parks, if the secretary, who's head of that agency, has a differing view of the proposed regulation, it creates a conflict of interest for myself. And I don't want to put myself in a situation where my law license could be put at risk. So that's why I mentioned in here that we would maybe need to have another position available where I would have separation for somebody who could run a rule and reg that would be separate from my client might be opposed to. I'm just raising that for the committee's consideration. I think that covers the broad points I was trying to make. I'll stand for questions at this time.
Any questions? Senator Francisco.
Thank you, Mr. Chair, and thank you for your testimony. Can you again help me understand the process through rules and regs. So you're saying this has to go through the rules and regs process before the commission votes?
Correct. It took me quite a bit to get on, understand this process, because what we do with the Wildlife Commission is, because those commissioners have the statutory authority to approve, reject, or modify, ultimately at the end of the process, what we do is we workshop ideas at our commission meetings, and then we get to a point where we feel like we've provided the commissioners all the information they need. We say, okay, commissioners, we know you have the authority to approve or reject or modify this regulation, so please give us kind of an informal poll, like, tell us if the secretary proposes this regulation, are you going to approve it? Because we're not going to waste our time going through the rules and regs process unless we know that they want the regulation. So we kind of get an informal go ahead to promulgate the regulation, and that's when I begin the process of taking the draft regulation, and I draft an economic impact statement, or my staff does, and then we submit it to the Department of Administration, the Attorney General, Division of Budget, and then I handle the back end on going before JCAR and, of course, noticing it up in the registrar. And it depends on what type of regulation. I don't want to get too far into the weeds here, Senator, but we have our Series 25 regulations on bag limits, which requires only a 30-day notice in the Kansas Register. And then all of our other regulations require 60 days notice. So I have to count backwards from our commission meeting and find that date to get it noticed up before our commission meeting, where the commissioners formally vote to approve, reject, or modify the regulation.
Are you aware of any other secretaries in our state that work with the commission? The one group that I'm thinking can make decisions is noxious weeds. We allow them to put individual plants on that list, but is there any other, any other secretary that, Health and Environment, that would be subject to the same sort of requirement that appointed individuals can also make recommendations about rules and regs?
Admittedly, I don't know of any other ones, but I would take that with a grain of salt, because before this I was doing appellate litigation. I was not involved with in a general counsel role. So, thank you.
Senator Alley.
Thank you, Mr. Chair. I guess I'm a little confused. You work for the Department of Wildlife and Parks,
Correct, Senator.
and you report to the commissioner, or the deputy secretary.
Yes.
What is your relationship with the commission?
So the commission is a separate legal entity that's created by statute that works alongside the secretary in our with these commission meetings and our rules and regulation process. However, my role, as I understand it, as chief legal counsel to the Kansas Department of Wildlife and Parks is, that is my client, not the commission. So that's why I'm making this distinction between the commission and the secretary, who is the head of Wildlife and Parks.
Do we have any other agencies that have that distinction, have a separate?
Yeah, I would say that when I was at the Attorney General's office and I was in the Logic Division, I represented the Kansas Water Office and the director there, and there's the Water Authority as well. I was not the Water Authority's attorney. I was the attorney for the Kansas Water Office. So now I don't think that the authority necessarily had its own standing attorney, but there are other distinctions like that.
Do you, and maybe you can help me with the language that was in there, but the language that it basically said requires on one, and then the other one was allows. What is the difference between require and allow?
Are you talking, Senator, about the introductory, the descriptive language at the beginning?
Right. It says on line 2, the act concerning wildlife and parks relating to the rules and regulation requiring members of the Wildlife Park Commission to submit proposed rules and regulations to such commission. And then over on, and we heard that from, I think we heard that from the general also, that it would allow members of the commission to submit proposed rules. What is the difference between those two?
Well, the one is mandatory, one is permissive, but I think the Attorney General is correct. That was probably just a typo, I'm guessing, on the requires. My understanding is the bill language just allows commissioners the ability to propose if they wish.
Okay. I think I've done. Thank you.
So you made a comment. If you are at a commission meeting, acting secretary or secretary is at the commission meeting, you are there and a commissioner asks a question that is of the legal nature, you're saying you cannot advise the commission as to what you believe would be the law on that particular question?
I wouldn't go so far. I mean, typically the question, sorry, Mr. Chair.
I was going to say, so if you would not go that far, then it sounds like to me you are working for the commission, not just Wildlife and Parks. And I see the Wildlife and Parks as a part, the commission as a part of Wildlife and Parks.
I see what you're getting there, Mr. Chair, but I think if they're, typically the questions we receive are basically, you know, Chapter 32, the statute says this, how's the agency interpreted that? Me giving an answer there doesn't form a lawyer-client relationship there with the commission. So I don't see that as me working for the commission by answering that question.
Okay, we got a difference of opinion, because if you're answering a question that's of the legal nature, you're advising a client. Senator Titus.
Thank you, Mr. Chairman. I'm sure the Chief Counsel is happy to answer who his client is in this situation. As a fellow attorney, it can be difficult as a general counsel sometimes. How many attorneys do you have? Are you the only attorney at Wildlife and Parks?
I have one other attorney. Terry Bruce is the other attorney in our legal division.
I know to a couple of the questions here, it's not necessarily a commission, but there are agencies that have sort of artificial separations. The chief engineer in the Division of Water Resource, where I was familiar with, has independent authority, the Secretary of Agriculture. And when I managed that office, we would often, well, there were cases where we would run out of attorneys, because if I had talked to somebody about a water issue, they weren't eligible if we had to split off the Secretary of Agriculture or split off the chief engineer. And we had a 5-attorney office, including myself, and the logistics of that could get difficult, or the problem is, depending on the issue, you have to assign somebody that has no background on the issue. So the concerns here are real logistical concerns with the attorney obligations. But have you had any discussions about in this rule and reg scenario where you could split your 2 attorneys and allow one to work on this and the other to work for the secretary?
Yes, thank you, Senator Titus. I hesitated to bring up your example previously, but I thank you for doing that as an example. I have spoken with Terry about this. He does, however, he's based in Wichita, and he does most of our transactional work, which we have a lot of. We have a variety of contracts with concessionaires and landowners across the state. I think at this point, I can say that we would need to retain an additional attorney to handle the separation here.
The language to me is a little vague when we say propose a regulation with, you know, how fully baked does the proposal have to be? If this were tweaked to allow the commission to request the Secretary of Wildlife and Parks to draft a regulation on a given topic, do you think that would alleviate your concerns because it would ultimately be coming from the Secretary?
Oh, you're putting me on the spot there, but that would certainly soften it quite a bit. I don't know if that could perhaps alleviate those ethical concerns. I hadn't thought about that possibility.
Spitballing here, we could talk offline about language or something. But anyway, just to illustrate, there are some real attorney concerns here. So I appreciate that, Mr. Chairman. Thank you.
Thank you, Senator.
Senator Shane.
Thank you, Mr. Chair. I think I'll just, build off of what Senator Titus spoke about there. So as drafted, would, in your opinion, would this prohibit the commission, from a commissioner, say, proposing a regulation change and then the commission voting to task the secretary to evaluate the proposal and actually draft the regulation? I guess it kind of piggybacks directly where, I guess I don't necessarily, I guess I would see discretion here that could be the case where, you know, commissioner says, I have idea X, the commission votes to essentially refer it to the secretary for evaluation and for drafting a proposal, and then it comes back to the commission. Could that be what this is envisioning?
I think I understand, Senator, I understand what you're asking. I think given the historical interpretation of the statute 805, which courts would look at when they're interpreting it, because the way it's been interpreted as the secretary shall propose all rules and regulations, that word propose has taken on a historical meaning of that proposal is the finished product as it goes through, you know, D of A, Attorney General, the promulgation process. So if the language were to stay as is, I don't think that you could say that if the committee votes and says we propose a regulation, and by that we mean we direct the secretary to draft the language, I think that would be inconsistent with the historical understanding of the term.
Okay, thank you. And I think that's helpful because that's what I was trying to understand is I think maybe those of us that either don't sit on with a legal hat, whatnot, we hear proposal and we might think something like I hear proposal and I think of something that's not fully fleshed out. It sounds like in this sense, proposal would be something that's fully fleshed out and essentially ready for a vote.
Thank you, Senator. I think, yeah, that's, thank you for the question because I think that helps clarify my point here is I think the word proposal has a distinct legal meaning in the Kansas Rules and Regulations Act, and I won't reflesh it, but thank you for pointing that out.
Senator Francisco again.
Thank you, Mr. Chair. And since we have a lawyer here, I'll put you on the spot. So the wording that's going to be changed is adding members of the commission shall submit to the commission all proposed rules and regulations. And would that perhaps be the reason that the revisor said requiring members to submit proposed, because it actually says they shall? You don't have to answer.
I'd say I don't want to speculate. I didn't write that language, and I really would like to not go there. Thank you.
Senator Titus.
Just to follow up for research that may be helpful for the committee, if you could look up, because I think we have a unique situation in that there's an executive secretary appointed by the governor, but there's also a commission that authorizes independent power. And I think if you go and look through the statutes, most of these boards that have a governor-appointed secretary are advisory. And they may review rules and regs, but they don't have as much authority. And we have sort of a unique independent split, which is giving our attorney heartburn and others in the clarity of who actually has the authority here. So I think it might be helpful to see, is there any boards that have as much independent authority or a similar independent authority, but also have a governor-appointed director? Because I might be wrong, but I think the Board of Pharmacy probably hires their own director, and then they are an employee of the board, but that's not the situation here. I think if there are any other cases where there's this weird distinction, it might be helpful for comparison.
Thank you, Senator Titus. Yes, this is a little unique in the fact that this governor appoints the secretary and appoints several members of the commission. That could be, to those of us who don't wear a legal hat, a conflict of interest. But final question, because we do need to move on. The fiscal note, according to Division of Budget, says that it would require another attorney to be on staff. I don't understand why it would require another attorney to be on staff. Could you not, if you had a conflict, contract out to an attorney for just that particular question?
I suppose I would have to research other scenarios where you could I'm unaware of another agency that would contract out a question that would run through a rules and regs process. Of course, coming from the Attorney General's office, I'm used to seeing contracts for defending state agencies in lawsuits, those matters, but I'm not entirely certain whether we could contract out an individual to just run a rule and reg.
All right. The reason I ask that, quite frankly, I do not see this legislature authorizing an additional FTE for wildlife and parks. Seeing no additional questions, I appreciate you being here. It would have been better had the acting secretary been here to appear on his own, but he was not. Thank you. Committee, we have one of those situations come up why the chair does not like WebEx testimony or anything online. And so going forward, the rules of this committee will be, unless there is a weather event, WebEx testimony will not be allowed. The reason I say that, we've got someone who has provided written testimony, but now they are online and they want to provide oral testimony, which I'm going to allow because it is Commissioner Mark, and he has been asking to testify, and he is a proponent, so we're going to back up, and we will not shortchange our opponents on their testimony. So Commissioner Mark, if you're still online, you have just a few minutes to briefly state your case.
I do appreciate that, Chairman, and I apologize. I've testified in front of the legislature there many times. I happen to be in the state of Utah testifying in front of their legislature today on another wildlife bill. I greatly apologize. I would like to respond to the attorney's comment about the conflict of interest, and I am a practicing attorney as well. The current regulation allows commissioners to amend proposals, and so the conflict that he raises is not possible, because if a commissioner were to amend a proposal that was brought to the commission by the secretary, the attorney would then have to represent the commission, as you pointed out earlier, Mr. Chairman, to draft the language of that amendment. And so under the current setting, because commissioners are allowed to amend, that absolutely would remove this conflict that they're trying to raise here. The problem is, and I've been a commissioner here for a very short period of time, that the secretary basically runs roughshod over wildlife decisions in Kansas. When we have a commission that has been appointed, and I love the way you guys drafted the legislation this last go-round, that allows the governor 4 picks, and then the House and the Senate and the Attorney General to have their picks, and then geographically adding that in. I myself, there's, I think, a majority of Democrats on the commission, but I've said this in every state that I've ever testified. Wildlife management should not be partisan. And whenever it becomes, whoever makes it partisan, somebody ought to look at them under a microscope, because they're making a mistake. And the attorney made the point that Mr. Secretary or Attorney General Kobach and I would like to make, is that he said, well, the secretary may bring this forward. By allowing commissioners to, as opposed to just simply amend current regulation proposals, but to propose their own, all of the rules would stay in place. The public comment period, everything that the attorney said that is a requirement would all stay in place. But what this would allow, senators, is for the diverse members of the commission to bring forth wildlife policy. There can be robust debate. There can be a presentation of both sides or all sides and many sides, and that can come from experts, or that can come from our constituents or these hunters and wildlife enthusiasts across the state. And even many times we'll have anti-hunters come to bring their point of view. And then ultimately, just like with every proposed regulation right now that comes from the commissioner or from the secretary, the commission will vote on that. This just gives us as commissioners an opportunity to play an active role in sound wildlife management. My last point is, in my short tenure, the only people that this particular secretary has brought to testify on any issue has been one-sided on the issue. I personally brought multiple pieces of accepted studies, and one of the most respected wildlife biologists in America who recently testified in front of the U.S. Congress on a wildlife bill to bring in the other side of the perspective. And by allowing commissioners who have been appointed from all corners of the state to propose regulations on their own. It actually brings more transparency to the wildlife management of the state. It brings more credibility, and always there will be this robust discussion, public comment, and ultimately, as it is now, a vote. Nothing changes with the exception of the commissioners, instead of being able to amend, we can actually propose. But there is no conflict for the reasons I said earlier, and I think Attorney General Kobach can respond to that as well. But I really appreciate you allowing me to testify via web.
Commissioner Mark, I appreciate your testimony. We will allow for brief questions before the committee wraps up. Committee, do you have questions of Commissioner Mark? We certainly do appreciate your perspective, appreciate the information. I think it's beneficial for this body as we move forward with a potential vote at some point in the future regarding the acting secretary. We, committee, will just temporarily suspend or recess from this hearing. This will be, Senate Bill 211 will be the first item on the agenda after turnaround. And since we have allowed WebEx testimony, if Lauren Still is going to testify and wishes to do on WebEx, past Commissioner Still will be the last WebEx conferee, again, absent a weather event for this committee. And then, Mr. Cobb, you will also be up first thing after turnaround. And committee, you probably have noticed this bill is an exempt bill because it was introduced in Federal and State Affairs Committee, so we can work it after turnaround. And we will see how things progress once we get back to the hearing after turnaround. I will advise you also on Monday, it is the chair's intention to see if we can get Senate Bill 80 and Senate Bill 184 in a form that is acceptable to a majority of the committee. So I would urge you between now and Monday to look at the bill. If you have proposed amendments, visit with our reviser of statutes, because that is what we will be working on Monday, is Senate Bill 80 and Senate Bill 184. I have nothing further for the committee. Do any committee members have anything for the benefit of the committee? Seeing none, we are adjourned.